Hello, everyone. Welcome to our webinar this month. Just a few housekeeping. It's being recorded, and we'll give you a link to the recording in your post webinar follow-up email that'll have survey information there. We appreciate your feedback. Your questions are to be asked through chat, and the presenters will address them when they can. Any unanswered questions will be addressed by email if needed. So with that, I'm going to pass it on over with no ado. It's all yours, gentlemen.
Thank you. So welcome. My name is Greg Kirsch. I am the Chief Operating and Compliance Officer for ANSI No More Forms. I also chair the Background Investigations Task Group of the SILA Agency Carrier Subgroup. I think I got that right. With me is Matt, calling in from what I believe is the most sterile looking environment on earth. Matt, if you want to give your credentials, that'd be great, and then we can get into this.
Yes. Thank you, Matthew Brombeck. I'm Vice President of Sales here at BIG. I'm also on Greg's background investigation group, and been in SILA since '99. So it dates me a bit, but my hair is about the same whiteness as the rest of my background. So hopefully I don't blend in too much.
All right, so what Matt and I are going to cover today is kind of why does screening take place in the producer environment? Where is the criminal history found and stored? What's the difference in some of these sources? Many of the pros and cons, and we did try to incorporate several of the questions that we received over the last several years. This isn't the first time we've done a webinar of this nature, though there always seems to be a great deal of interest in the criminal history screening process. So we're just going to jump right into it first with the why. Why does screening even exist in the producer environment? The primary answer is, in case you're unaware, there's an act called the Violent Crimes Control and Law Enforcement Act of 1994. It has a very specific section in it, Section 1033, that discusses the information that a producer or someone that's engaged in the business as it relates to insurance, and I'm paraphrasing there, they must be free of any felony history involving dishonesty or breach of trust or any type of fraud type event. And it is punishable by, if you read at the very end, anyone that permits that to occur shall be fined as provided in the title or imprisoned by not more than 5 years or both. So basically, the basic guideline here is if you're going to permit someone to engage in insurance, you have to ensure or attest to the fact that they are free of that type of event. That can take place in two areas. There's the licensing phase, so that's why the departments of insurance screen and do the fingerprint screening at the point where the individual's getting licensed, but there's also an interpreted requirement on the actual parties to in turn do that. Matt, do you want to provide any color around that before I jump into that the whole waiver concept? Just a little teaser there.
Yeah, I mean, there's a big difference between what a state is going to view as dishonesty or breach of trust versus what a carrier, somebody in the industry, would likewise consider. It oftentimes comes down to cost versus risk. The state may be looking for something slightly different. Each state may look at things slightly different, and it's beholden upon the carrier to have some level of due diligence to make sure they're at least meeting some of the expectations here. And from an individual perspective, if they know they have a particular crime, and leading into what Greg's going to be talking through, some documentation that needs to be filed and kind of a get out of jail free card, if you will, for that particular situation.
And one thing that's I think notable in this is that the 1033 requirement that's placed on insurance carriers or individuals in the insurance and security space in general is that the act is specific to violent crime control, But this is, you'll notice it's absent any references to violent offenses or sexual offenses, other severe offenses where, again, this isn't why you should screen. This is more what is a requirement in the process in order for someone to engage. So there's a very different conversation too about company policy that that you can always get into as far as what represents your brand, people interacting with the public, things of that nature. But jumping into the 1033 waiver. So for those of you that we've talked about 1033 itself and what the requirement is. The 1033 waiver is very specifically if someone has an offense that falls under that category, those categories of crimes that's listed in 1033, they can apply for a waiver at the point of licensing with the state that would say, look, I understand I have an offense involving felony fraud, but it was in Florida, it was 25 years ago, and at the time, a bad check of more than $200 constituted fraud or something like that. So that's just one example, but they can submit and request a waiver that would allow them to still go on and engage in the insurance business. And the thing that's important about those waivers is that waiver is issued by the state. It does not have to be honored across states. It doesn't have to be, if the state of Florida issues that waiver, it doesn't mean that the state of Wisconsin would have to accept that waiver during their licensing process. So in many cases they do, but it doesn't have to, and it also doesn't necessarily mean that you as an organization have to honor that waiver, but it would certainly be in the organization's best interest to ask the question, if someone has those offenses, do you have a 1033 waiver? And if so, can you provide a copy of that or something like that, documentation around that to be considered in that overall process? So
Greg, there was a question here about a waiver showing up in a background investigation. And, it's not a public record, if you will. So it would not be something otherwise that you would see. The waiver is not itself tied to the court case or the conviction that may be reported. It's otherwise something filed with the state that the subject should be able to present and provide, as proof. But it would not be something that would be a public record that would be reported by, Applicant Insight or Accurate or any background provider.
So the next quick subject that we want to talk about is we talked about the federal 1033 requirement. And I don't think we emphasize that enough, that 1033 requirement is federal. It is not specific to any state. It covers all U.S. business, basically, and U.S. territories. So now we do get a lot of questions. We see it in the SILA forum about what states require a background check. And there's no clear-cut answer. As a general rule, based off of the read of the 1033 language, each individual state or each individual entity is required to comply with 1033. That's a statement of fact. Whether or not you accept the licensing process as a validation that the person is free of those types of incidents, that's a risk factor that I'm not particularly comfortable with based off of the things that I've seen in screening. But if you are interested, SILA has a lot of information within the SILA Digest that talks about what states require it. When I say require it, it's an interpretation where you're at the time of appointment, you're attesting to the fact that they are free of those types of offenses. So it doesn't say you have to do background. It's not that black and white, but it's at the time of appointment or prior to appointment, you can attest that they are free of this type of language. So there's about 15 of those states generally that seem to be interpreted as having specific call outs to that. But again, the Federal Violent Crimes Control Law Enforcement Act is an overarching umbrella, and it's going to apply to everyone. And I know just from some of the surveys that we do, 90+% of the SILA membership conducts their own individual screening in addition to whatever might take place at the licensing phase.
There was another question about waivers in the accuracy of not all states issue waivers. And I don't think either Greg and I could really, speak to states, all of them. Everyone has their own position. They have their own risk, threshold about whether or not they issue any, or for specific crimes, or maybe based on age. I'm sure all of that's taken into consideration on an individual by individual basis. But Greg, I don't know if you have any further insight into that.
Yeah, just because it's an option doesn't mean somebody has to exercise it. So I mean, it could be well within their purview to admit issue them. But again, to say some states don't do that at all, that wouldn't surprise me. I can't say that I've ever done any data research to specifically validate that, but that wouldn't surprise me at all. And another thing to think about too is in that licensing process, typically they're looking for those felony offenses that we just referenced. There could be other felony offenses that don't fall directly into those categories that don't prohibit from licensure, but may be a risk factor that you would want to consider, particularly if you have individuals that are dealing with the public, going into people's homes, things like that. So now, one of the questions we get asked a lot, I'm not going to jump too much into this, but I thought this slide was important. This is from one of the, we do membership surveys every couple of years, the task group does. And this is just the most recent that shows, from a respondent rate within the SILA membership, you could see the highest percentage. So, 60, 70, 80, 90% of the respondent population is running some sort of background investigation on their own, in addition to whatever may take place at the licensing phase. Or so, and when we say this, some of these elements are going to be what we're going to really dive into here in a second, which is the address history, the county criminal search, which is one source of information, the federal criminal search, which is another source of information, statewide where available, and then multi-jurisdictional databases. These top elements here are, you can see, pretty high use products. I say products, but consumer reporting tools that identify potential adverse criminal history information. So having explained the kind of the why does background screening exist outside of the licensing environment and even within the licensing environment, 1033, individual state requirements, waivers, interpretations, what is and isn't considered there. What we'd like to do now is do a deep dive into where criminal history is actually found. So this is a little bit of a criminal justice 101 almost, as far as how an event, an arrest ultimately becomes a case, and then where the information is stored, where it's funneled up to and passed through the process. So the first thing that Matt and I want to preface in this is there is no one-stop shop, single source of someone's entire criminal history across the country. There's tons of individual sources that get merged and aggregated at different intervals, or not at all in some cases, and get reported up. But it's not like in the TV and movies where you just run somebody's fingerprint and literally it's a 100% accurate list of everything that they've ever done wrong, going back to their 16th birthday or something like that. So the source I'm going to start with is the county and municipal court system. It goes by different names in different areas. In Louisiana, they're parishes, but basically these are smaller subsets within an individual state. And this is where the vast majority of criminal history is tried and a disposition is rendered, meaning someone was arrested, the court decided to take it on because there was enough information there to actually file a case. And then there is, through the course of the case, a determination of guilt, or I can't say innocence, but lack of guilt. And all the other in between stuff of adjudication withheld and things like that. But you're talking about individual court systems all across the country, the 3,400 ish, I believe, counties and county equivalents within the country. It is the single best source for a complete history of what took place with that individual on that offense. So an example would be, even if let's go with like state of Pennsylvania, someone gets pulled over in the state of Pennsylvania by the Pennsylvania State Police, not a local county police, the state police, and they get charged with DUI. That DUI is still going to be tried in the county that they were arrested in, or maybe the county where the individual resided, depending on that area. But again, most of that history is going to it's going to transfer into the county. They're going to try it. They're going to render adjudication, provide sentencing, and then from there it may go into other sources. But it's the single core source of that. The only other place where criminal history is truly created would be a federal court system, which we'll talk about in a second. I mean, Matt, we could do an entire hour on the county court system, pros and cons, DOB, identifiers, common names. But is there anything specifically that you want to, add into this before we jump to the pros and cons?
Yeah, it's all, when you're arrested, it's where you're arrested, what you're arrested for is going to dictate. This is just your high level, misdemeanors, your felonies. There are a sundry of other lower level town courts that handle some infractions. So your programs are typically, this is your base, your starting point. That's going to really get you the key elements that you're looking for to mitigate your risk of the 1033.
Yeah, the lower courts beneath this, which would be, there you'll find things like ordinance violations and what they might call summary offenses, and things that technically under a lot of definitions don't qualify as criminal history. They're violation based. It's not offense based, but you're getting into some of that language varies from state to state and within their thing. But within one county, you can have 14, 15 individual municipal courts that take on the low summary level offense stuff in their local township, and then the main misdemeanors and all felonies are tried at the county seats or something along those lines. So thanks for clarifying that. The pros and cons on this, we're going to spend more time on this than many of the other elements, but the pros and cons on the county court system, again, if you're going to walk away with anything on this, it's a direct source. It's very detailed history, beginning to end timeline of what took place around that with sentencing. It is publicly accessible. It has to be publicly accessible. It's under the United States Constitution. That is how it's determined whether or not an individual was afforded their due process. So the reason why this stuff is publicly available, there's no county court in the country that is not available for as far as its records. Generally, information is very reliable and up to date as to the last event that occurred. And there's also sometimes, depending on age of the case, there's clerks and there's other personnel within those courts that can help dig up additional information when something might be incomplete on what we would call the general public access. But there's a whole host of cons too. It's a name-based search. So, if I went by an AKA, if I went, if Greg Kirsch, but I committed an offense under Matt Kirsch, those would be two very different searches, two individual search events in most county environments. The identifiers can be somewhat limited, as you don't have NPN's not on there, unfortunately. Social security number, things like that are rarely available. So it's usually using a combination of multiple identifiers. And there's a whole host of other, minor cons in it, but overall it's the most accurate source for that information, but it is a somewhat contained environment. If you're going to search Philadelphia County, you're only going to get events that occurred in Philadelphia County. You're not going to get events that occurred one county over, or so it's not a large net as far as when you're fishing for the information. The other source, and I'm going to touch on this briefly before we get into some of the we'll call it more the database type systems, but the other true source of criminal history is federal district court, much like county courts in their structure, but just larger. It's a federal district court. There's far less of them in the country. So for instance, New Jersey, it's a fairly large state, only has one federal district. So But those would be crimes that were violations of the federal crimes code, which in many cases states have laws that also mirror, some things in the federal crimes code, but just go much deeper. But ultimately, you'll find crimes where there's no real jurisdiction to the crime. So crimes that cross state lines, high profile crimes, and take place in federal district court. So you get a very, very low hit rate, but when you do get a hit in a federal court, it's usually a pretty big deal because it's a felony pretty much right off the bat. The only misdemeanor that I recall seeing in a federal court was because it was a misdemeanor DUI that occurred on military property. So, and for some reason it didn't take place in military court. So, but generally, you're talking about some pretty severe felonies. And also with the federal court, they don't really push their information anywhere else. So that's going to come into play a little bit later, but you don't see federal conviction history being pushed into a lot of these data sources the way some of the other courts do. The pros on it, again, similar to counties, it's direct source, detailed history, publicly accessible. But the cons, the search process, common names are somewhat burdensome to validate. There's limited identifiers within that, less than typically found in the county court system. And again, it has a limited scope, so it's a slightly broader net than a county search. But this, if something happened in the Eastern District of a state, and you're searching the Western District, you're not going to, they're not going to cross paths. Though they do have a centralized search system that is helpful in a way that many of these counties do not. So those are the two court systems. That's where criminal history is tried, guilt is determined, sentencing takes place. Now, Matt, can you maybe take a couple minutes here and explain kind of the state repositories and where that comes from, and then how that's going to relate to the national or the federal FBI database? Some of those things. This is, I think, where I might talk too fast and breeze through this, and it's fairly nuanced here.
Yeah, absolutely. So, where Greg was speaking about this very decentralized, you have a crime, you have a record, and it belongs there. The court system was designed to record these events, not necessarily designed for companies like us to access easily and have a broad spectrum or broad scope of an individual's past. So many states roll that local information up into statewide repositories. Likewise, from a police and arrest perspective, there's also roll up into statewide repositories that track arrests, fingerprints, and that sort of thing. So when looking at statewide, perhaps in your program, you're doing this cost versus risk analysis and you want to expand a little bit, but you don't want to do additional counties. You can look at a statewide, maybe a state offers what's referred to as a Office of Court Administration, or as individual agencies roll up into a statewide repository. They oftentimes will offer that online. It's oftentimes very quick. You still run into the same constraints of name matching and stuff like that, but you get a bit broader of a scope in terms of access. Now, some states that don't offer that will offer something more so akin to running a fingerprint check through a state repository of arrests, of crimes that the police will roll up. Now, oftentimes those states and that access point is regulated. Sometimes you can only access through fingerprinting. Sometimes you have to be in a regulated market or a regulated organization in order to even access state information through fingerprinting. So there are, and as we kind of work through the presentation here, the scope potentially expands a little bit, but not without some of the challenges that we've seen on the county and federal records. From a pros and cons to this, you see a lot of the similarities. Name-based checks limited to simply that state, but you also get some of the benefit of a much quicker turnaround time, a much easier facilitation. A lot of the records tend to be online for these.
Yeah, and one of the biggest cons on the state, let's call them the publicly accessible state repositories, is they often come at a higher fee. There's an access fee for certain state repositories in a way that doesn't typically exist at the county level. I mean, there's obviously exceptions that some counties charge access fees, and they can, but most state repositories will charge a fee, and it can range from the New York OCA fee is 80, maybe. So it's very, very high. Some of the state repositories, $10, $15 is not an uncommon range for some of those fees. And also they're not available in every state. So if you are screening candidate population, producer populations on a nationwide basis, there's some states where it has a repository, but it's only available through a digital fingerprint, perhaps under only a regulatory purpose, as Matt mentioned. So it's not the state OCA or state repository is not as common of an option, but again, it is an aggregated source of information, and it's run by a state agency. Now let's go to the largest of all state agencies, and that would be the FBI, as far as an agency of the state. Matt, do you want to expand a little bit on how the county and federal district, county court and federal court stuff that we just did, talked about, tries the information, then pushes the repository of the state, and then the states report to this. It's like a backwards Ponzi scheme. But yeah, if you want to go through and kind of speak to it.
Yeah. And top of the Ponzi scheme is the
it's
FBI.
the top of the Ponzi scheme. Yeah.
Right. The sources that we've talked about up to this point are publicly available. Greg mentioned, courts. All of the courts have some level of public access, whether it's online, whether it's through some API, or whether it's literally their only option is walking into the courthouse, handing a form to the clerk and asking for information, and the clerk will oblige. It's public. Now, when it comes to the FBI, it's less about what you can do and more about what the FBI permits you or grants you permission to do. Now, every arrest that happens out in the field, there's some expectation, some requirement that information ultimately get reported up through to the FBI. Now, does that mean that the arrest will lead to a conviction? Does it mean that arrest will lead to something down line? Not necessarily. The FBI database is a national database. It encapsulates information that the states report, that the federal government reports. And so where you have this decentralization of county level courts, your federal jurisdictions, all of that ultimately will be rolling up into the FBI database. Now, the big challenge with the FBI database is you can only access it if they give you permission. There has to be a federal law, a federal act that specifically grants you permission to access their records and use those records for a very narrow focused permissible purpose. And so the benefit of being able to use the FBI database is one of comprehensiveness, and it covers a lot of ground. But the biggest challenge is that it's only allotted to a segmented population. Now, if you happen to be a bank or an insurance carrier or a securities firm that is related to a banking institution, there is a public law that permits banks to do fingerprinting for employment purposes. So literally can run a fingerprint to determine whether or not that person has any crimes, and that's driven by the FDIC. short of that, most of the other use of fingerprint is for a regulated purpose. The states can have the authority to access the FBI databases for state licensure. So you may, as part of an individual's license, get fingerprinted. That fingerprint is processed through the state, and the state may have authority by the FBI to access the FBI records. Now, sometimes the state simply has access to their own state records, and so a fingerprint may be a fingerprint, but not always the results are the same or are equal. Now, although there's some requirements that local authorities are supposed to roll up information into the FBI repository, it's not always the case. The FBI is the first to admit there's no checks and balances. While required, it's not necessarily enforced. So there are a wide swath of records in the FBI database that simply have an arrest, that do not have a disposition associated to that, which makes it sometimes challenging from a state perspective. If they have the authority and run a fingerprint, they may see that the individual was arrested a long time ago. There's a lot of effort and a lot of next steps in order to work with that subject and work with that individual to determine whether or not there was some resolution, whether there was a court case. And that may be why sometimes an individual's license comes back very quick versus takes a long time with a lot of dialogue with the individual. It's a great tool to have, but unfortunately, just a bit more limited to the regulated industry.
And I'm willing to bet almost no parties on this call outside of Department of Insurance representatives would have any access to this in most cases anyway. So it's it would be nice to have, but it's generally not an option. Now there's another product, I'm calling it a product, but and this is more of a product than the other stuff. The other court stuff that we talked about is actually direct searches, but there's a product, and this is it goes by many names. You may hear it called a national crim. You may call it a crim hit, crim watch. That it's a proprietary database, and there's several of them in the market that background screening companies offer, and there's very scaled down versions. You might see it if you ever just go online and say, want to search somebody's background. The first thing that pops up is a $5.99, pay this now and get find out if someone has a record kind of thing. What those are is it's just a multi-jurisdictional database. It's a database that has aggregated purchased information in bulk, done screen scraping and bots and all sorts of other things to just collect and aggregate information from anywhere that it's been digitally available at one point or another. So it's a very effective investigative tool because it provides potential pointers towards where criminal history may be. But again, it's not the source of that history. It's just trying to, it may cover one area very densely, and it could be one county very densely, and it may not obtain any information from a neighboring county. It can be that spotty in its coverage. But so usually, in what I would consider to be Fair Credit Reporting Act compliant environments, when information is found in this type of product, the potential hit is then processed through a direct search of that source, whatever county it may have occurred in, or a federal district, or whatever nationally maintained database that may come out of. So it's a very valuable tool in the background screening process. I wouldn't recommend it as a singular product in anything. To me, it's a supplemental tool for if you're thinking best practices. But it's a very, very large net, but it's got some giant holes in it. It's a patchwork net that just kind of throws across a giant area, and also includes a whole bunch of stuff that's public record, but not technically criminal history related. So again, very valuable tool, but you do have a high likelihood of false positives and false negatives. False negative being it reports clear, but there actually is a hit, because if you have someone that's spent their entire life in Louisiana, for instance, their information is notoriously not digital in their parish court system. So there hasn't been a lot of aggregation that's gone on there to collect that. So they could have history all throughout the different parishes in Louisiana, but a national crim search on that would come back clear. So there's pros and cons with this. It's again, it's a tool, and combined with others, it can be a very impactful value add, but as a standalone, it's not advisable. So everything we just talked about can be summed up with this grid. So maybe we should have just led with this grid instead of talking about it, but I think the context that hopefully we've been able to provide helps. But this grid is kind of the main takeaway of the 5 main places that criminal history can be found, can be stored. Some of it's in duplicate to the other places. You know, as we mentioned, the county courts report up to the state repository. So there's basically the search type here. How, you know, is it strong in its accuracy and compliance? How does it apply to the Fair Credit Reporting Act? What are the search criteria that are typically used when trying to conduct a search of that source? And who is it available to? The public, consumer, CRAs being a consumer reporting agency. That's what background check companies are. So, so this is, you know, if you have questions about this, again, we could probably break this down and spend 20 minutes on it, but I do want to get into, you know, tying in some of these tools and then running through some scenarios. And Matt, if you're tending to the chat, that would be great, because I don't even know where to find the thing. So evidently but I'm just going to keep going unless you see something that's particularly relevant. Otherwise, we'll try to grab all this stuff at the end. So.
Yeah, I've been keeping an eye on it. The only recent question here was about the listing of the states that have their own language about the Violent Crime Control and Enforcement Act. I believe that is listed in some of the SILA documents, if I'm not.
I'll jump back real quick just because I don't want to be on record saying that those are the states, because I can't, again, there's a lot of different interpretation, but in the SILA Digest, and under the Resource Center, there is a guide, and it's called State Required Background Investigations Quick Guide. If you download that, if you know, with your SILA credentials, you'll see there's a thing about where initial appointment and additional appointment columns. Anything that has the number 2 in that, it basically, and there's a key down at the bottom, but just to save you some of the history there. It's references with the regulatory guideline where that information is, where it states that you're attesting to that they're free, or an obligation to, you know, something that is more forcefully implied of an obligation to run. So I'm going to say it's about 15 states, maybe 17, I don't know. And that information can change. Sometimes you ask a regulator and they say, yes, we require it, but they don't have that language, or you point out that language to a regulator that hasn't, like, I wasn't even really aware it was there, but yeah, we do it. So good luck and Godspeed on that. But yes, there is a guide, and it's referenced, and the slide deck is available if you want to download that after. I want to talk about address history, just because it's very important. We talked about how all these little targeted searches, the county and the federal court system, whether or not you include state repository and you have a national crim, there is a tool that a lot of consumer reporting agencies use, and it's highly recommended you use it in your screening program. And it's just something that identifies through a mass aggregation of data from all sorts of different sources, an individual's name and address history. Using that, it allows it, if you rely solely on what an individual provides to you, then you're just keeping honest people honest. Like, you know, someone that's trying to be deceptive will just not provide you the name variant that they have criminal history under. So the idea is you build this into your program. You have you identify the name and address variances, you run that national crim database, and then you start, you've identified your jurisdictions and the areas you want to look and possible hits, and then you start doing the searches to get as comprehensive a tool or as comprehensive a result as you can. So again, combining all of these things into, hey, look at that guy, he's got the same beard and glasses as me, how about that? So if you combine all these tools into one kind of product and you sequence them out properly, you're going to get 99.999% of all the potential criminal history that could be out there, because you have your national crime database to maybe pull a I don't know, a drunken disorderly that took place when they were visiting the beach and for the summer, something like that, where maybe they didn't have residence history. It just helps kind of sew all these things together into one comprehensive screening for a price point that is I guess that the market will bear. State repositories are an optional add-on, but some of them have turnaround time increases. Possible hits can take 2 weeks, 3 weeks, depending on different states. There's an additional cost that goes with it too. So it's an option out there, but arguably, if the majority of criminal history takes place in counties or federal districts where someone has resided or went to school or worked. So most of that should be identified in this. So, and I say this not only as a background screening organization, but also as as an employer. It's the same level of due diligence that we do on our own employees too. So
yeah, and your level of comprehensiveness, can potentially change depending on your distribution. Career captive agents, you put in a little bit more effort into onboarding them. You cultivate them, you enrich them, and you may want to do something a little bit more comprehensive for them versus an independent who just wrote some business. You don't have a lot of effort into them. They're also independent. They've likely had investigations run on them over the years to other carriers that they're appointed to. So this cost versus risk is really one that is inherent to each organization. It tends to vary. It could also be simply because of your size or your marketing. National organizations may have a different threshold than and deeper pockets than more regional in nature. But Greg's laid out a very, very solid package to consider, to be sure.
and if you have to do like screening at the renewal phase or something like that, and they've already been with you, there's an argument you could reduce the scope. You can only do it for the last 3 years or of address history or something, or to refresh if your program determines that there's a need there. There's different scope look backs as far as the address history and stuff that you would want to look for, but again, it's a risk cost. Now, one thing I can absolutely say for certain, if you're not screening your producers in any way now and relying solely on the licensure phase just to indicate whether there's history, at one point or another, you will definitely get information back doing your own screening that you'll wonder, how did this pass the licensing phase? And that's because of some of the things that Matt and I just discussed in great detail about. This thing may have happened, but it never reported up into the state repository. Therefore, it never made it into the federal database and the FBI database. So it never pinged on the fingerprint process. Again, there's no perfect process. Marrying these things together properly is what makes it successful. So I have a scenario, and we should be able to go through this scenario fairly quickly, but let's just assume that we have the gift of hindsight here. So we have an applicant, whether they are produced a captive or whatever it may be, but just some individual that we're looking to screen, and we have this person with these credentials, and we have, again, the benefit of hindsight, knowing that this person has a whole bunch of different alias things, hyphenated last names, first middle name, combined, and we know that they've lived in different areas. And we also know, again, hindsight, that they have this type of history across the different jurisdictions of their, this type of criminal history across the various jurisdictions of their address history and stuff. The reason I'm hoping for those that are visual in this process, we can kind of do a breakdown of, if we do a package that is only, and I say package, it's the search components. What have we married together to try to identify history here? If you do a package that's only the current county and only the federal, and you're only doing the provided name, so you're not running any type of address trace, so you don't know about any of this information at this point. you're going to run this search, and assuming that this is that person's history, you're going to see that there's no records in either one of these things. The person's clear. Great. On board. Fantastic. Let's run with it. The exact same scenario, but instead all we're doing is adding the address history. So by adding that address history, we've added a couple of kind of new avenues to identify and then look into different things. But I'm sorry, in this scenario, we have the address history, but we're only running the current name. So now we've got one hit in this area. We've got several other clears, but we went from a 2-point inspection functionally to now we've gone into a 6-point inspection, and we've actually found an area of concern because we knew where to look at that point. The third variable, and this is again going from kind of lowest in due diligence to highest in due diligence. The third option is running the county and Fed developed from the address history, and we're doing both the current and the AKA names, so previously used name, married names, things like that. Now it's gone, the number of points of inspection have increased, and we've revealed more history. We've revealed history as a result of this in this area that we wouldn't have gotten otherwise, because of the nature of the combinations of the variables in. It's almost, you hear sometimes when people talk about databases, garbage in, garbage out, that's just it. Like the nature of what we're putting in is determining what the output is. And then this option is running, kind of the whole thing, plus you get that national crim, which is pulling, the person had no address history whatsoever in Chester County, Pennsylvania, but they have a bad checks claim there. And that was only identified from the inclusion of having a NAC crim database in addition to the counties and the federal districts. So I hope you found that helpful to kind of diagram out how this might work, how this might play out in a known, knowing, with the benefit again of hindsight, what that could actually look like and how that would run. So, and if you needed this kind of a summary of how those things laid out and the different things that pointed out to it. So again, it's all in the slide deck. This one's hypothetical, but anybody that's been doing background screening long enough can say for certain that any scenario that I try to make up here is going to be what the scenario that ends up on my desk the next day of a real life thing that happens. So
for sure.
And oh yeah.
So Greg, before jumping off of this, so we went through kind of what should go into a request. We have a question here. Can we share our thoughts on the insurer passing on the requirement to do background investigations to the agency through a contracting process? So effectively, a carrier engages an agency, and through that contracted relationship, the agency is required to do the background investigation on the individual. I'll let Greg opine on the legal. In my opinion, you're kind of passing the buck. Ultimately, if the agent is going to do bad, the deeper pockets are going to be tapped in terms of any legal challenges. And if a state is coming in doing a market conduct exam, they're going to be expecting you to have some due diligence on your own. But Greg, you're into that much deeper than I.
Yeah, I mean, you could transfer the responsibility, but I don't know that you could transfer the liability. Is probably the best way to say it. I mean, you could put requirements of what needs to be screened. In most of the cases I've seen, and even going outside of just the insurance environment, there's when that's passed on, sometimes there's a difference in what's being run because the translation, like you say, hey, I want you to do this that includes a 7-year this and that, and then they'd go, okay, I heard search the provide name for 7 years and that's it. So there's I mean, ultimately, I guess that there is a transfer of liability conversation there, but under the larger 1033 requirement, it's anyone that permits somebody to engage in the business. So I mean, look, this is an insurance environment. We're all about risk here. You understand the risk of that. So there's a belt and suspenders approach, and then there's a no, I think I can pull this off. But like you said, if there's an event, which hopefully there never is, but if there's an event or there's an audit or something like that, that may come to light. So it's a gray area. It's a gray area. And the only other slide that we have here is just 7 years, and this is just because people seem to ask, why is 7 years so important? Why would it come out? Why does bad information fall off my credit report in 7 years? Why? It just is, would be a short answer to it. So it's served well as a predictive time frame that has withstood the test of time when it comes to balancing fairness against the safety. That's the best quote that I can find for it, but generally speaking, you want to look, you want to develop 7 years of address history when you're trying to identify, potential history, but I wouldn't by default limit my search in the criminal county jurisdictions to 7 years. You pretty much want whatever's available. The 1033 requirements do not limit it to 7 years. It's any felony involving fraud, dishonesty, breach of trust, functionally what it is. So, you want to make sure that you're mindful of that as well, because sometimes there's a devil in those details there about how that plays out. But 7 years is in the Fair Credit Reporting Act. So consumer reporting agencies can't report adverse information older than 7 years, except for convictions of crimes and a handful of other lower use clauses. But so just for the purposes of explaining kind of where that comes from, why it's there. It's all over the place. It's in the Fair Credit Reporting Act. It's in the EOC guidance and of individualized assessments. So, but yeah, that is.
Greg, before we jump off of this, there was a comment by someone. The uniform application says, "Have you ever?" And that's the 1033 doesn't say, have you ever had a felony of dishonesty or breach of trust in the last 7 years or in the last 5 years. SDIC has no time frame. FINRA has no time frame. They're expecting that if something ever happened, that it be called out, that it be taken into consideration. Now, utilizing third parties, Greg, myself, Accurate, and some group of others, we're consumer reporting agencies. We have some requirements and potential limitation of reporting of information because of who we are, because of how you may utilize us. But the expectation is that you're uncovering as many stones as you can with these individuals, and it's the ones that do wrong that tend to hide their past a little bit better than others. All to take into consideration.
It is an exception game. It's very much about managing to the exception. So, because you're only looking for a handful of nefarious actors. So, and yeah, again, all the content is available afterwards. You can see the excerpt of 1033. It's very specific. Conviction of any felony involving the period. There's no time frame. Non-convictions, deferred adjudications, all that kind of stuff. Those are some detailed conversations that we can unpack. But whether or not a plea of guilt that ultimately is a non-conviction disposition falls under that. Those are all things that there's a lot to unpack there. But
yeah.
And Matt, any other questions in the chat, or what are you seeing here?
Well, what, there is a couple. While talking about this time frame and about what an individual may have admitted to, there's some things that you may need to consider on the front end as well. There are ban the box laws about asking certain questions. There are expungement laws that are starting to take hold, and so some organizations may feel that they're being pulled in multiple directions. We're coming at it at a holistic look at in the insurance industry what your requirements or what you should consider to meet the crime bill. But obviously, when creating a program, you have to take into consideration a number of different aspects of other state laws, other federal laws, so it's not a straight line, unfortunately. Now, there were a number of questions here, one of which a PDB. The question was, anybody scan the PDB for appointment termination for cause and have this part of the background review criteria? The PDB is oftentimes utilized as a barometer for the individual. There's a lot of information that can be gleaned from the PDB. It is also FCRA compliant, all of the same things that Greg and I have been talking about in terms of reportability, authorization. That also has to be
you're saying the PDB is regulated by the Fair Credit Reporting Act? Hold on, please tell me more. Tell me more. Yeah,
I don't think we want to go down that path.
I thought we said we weren't going to have that conversation because that's a webinar unto itself. But please, if you want to go there with 2 minutes left, please fire away.
I wanted to make sure we were limited so that there's not a lot of questions that can come up. But I was just, as far as what you've seen, I assume PDB is a major component in the programs.
Yeah. And particularly if there's regulatory events that are found in the PDB, the deeper dive on some of those to kind of access some of that information. The PDB is a consumer report. If you bring some of that information into the background check process, it's all part of the consumer report. So then you're talking about multiple consumer reports on a person. But yes, it's a public record. It's information being gathered by a private entity from multiple states that is then made available to query and determine someone's eligibility, and therefore falls under the Fair Credit Reporting Act. So.
Now, while talking about the FCRA, we have a question here about FCRA is good for how long? And I suspect the context may be an individual providing authorization. How long is that good for? And the FCRA does not have any time limits, and as long as there's evergreen language or some ongoing expectation that it's to be fulfilled, the FCRA does not necessarily have a time frame or a termination frame. But there are some states that have their own version, California, that oftentimes lend itself to collecting a new authorization each and every time.
And so it also falls into the question of permissible purpose. So it's basically, when does your permissible purpose expire? And that's what that's asking. As long as they've been in your employer contract or whatever it may be, and that hasn't expired, then and everywhere but Florida, basically that authorization is good. Now, the reporting of information under the Fair Credit Reporting Act, that is limited to adverse information greater than 7 years cannot be on a background check report, other than conviction of crimes. So non-convictions, a non-conviction cannot be reported older than 7 years, but convictions of crimes crimes resulting in conviction can be reported greater than 7 years. Bankruptcies can be reported for 10. And there's a couple other scenarios where some of those limits don't apply if this person's expected to make $75,000 or more annually, and a couple other things. But generally speaking, you're talking about a 7-year limit on adverse information that's not convictions, and then convictions can be reported on an unlimited scope. But as far as when you run the background check or how often, that's vertical specific. So and organization specific upon initial appointment, upon renewal, based on your presence in certain states, how far back you're asking to look, because we'll look at Matt or my organization, we'll look at basically what's available in the commonly or predominantly used public index of that individual county search. So some counties may have information available for 15 years, some may have information available for 12, some may have it for 25. It really depends. There is a limiter at the source where stuff that was never digital, ultimately never got filed in 1990. They were like, all right, we're going to file everything from 1990 forward, and everything before that, it's in the basement somewhere, covered in mold and dust. So.
Excellent.
All right. Look, a lot of chat around Pasco County, so I'm not the only one that's My company's in Pasco County, so that's fascinating. So
Yeah, there was
that's-
a lot of your example, so good pulling up the example, but I think you may have offended some of the folks living in certain jurisdictions, but
strictly a fictional person, just made it up. So, well, again, thank you to everyone that joined. If you ever have questions for the task group or you know, or you want to join the task group just as, you know, an observer or a participant, please feel free to join our background investigation task group. We meet, depending on our level of activities, monthly, maybe once every 2 months. Usually have a couple things where we do to try to dig up some of this information, and you can also post your questions in the forum throughout the year. We try to chime in. Diana's really great at, when she sees a question that's background related, sending it out to the task group, and so we can formulate a response or kind of help out. But yeah, you know, on behalf of myself and Matt, thank you so much for your time this afternoon, and I hope you got something out of this.
appreciate it. Thanks, everybody.